Good afternoon, everyone, and welcome to today's webinar. Today's topic is Staying Compliant in a Turbulent Time and will be presented by shareholder Amy Klum-Holbrook and attorney Stephanie Kempfer-Collier. Before we get started, I would like to take a moment to go over a few housekeeping items. My name is Hallie, and I will be the webinar organizer for today. We want to make sure today's presentation is extremely valuable for you, so we ask that you submit all questions by clicking the question button in the control panel and typing your question. Your questions are only visible to me, and I will collect and submit all of them to the presenters throughout the presentation. Additionally, we will have some time at the end for any final questions. Before we get started, I would like to provide some brief background on today's two presenters. Amy Klum-Holbrook, shareholder, brings over 15 years of legal experience to the firm's Cleveland office and primarily practices in the Collateral Recovery and Reasonableness group. She has been selected as an Ohio super lawyer and was named to the 2010 list of Ohio Rising Stars. She participates on the Women's Leadership Council of the American Financial Services Association and is a member of the Ohio State Bar Association, as well as the Cleveland Metropolitan Bar Association. Stephanie Kempfer-Collier is an attorney practicing out of the firm's Chicago office. She primarily practices consumer collections and collateral recovery and reasonableness. A member of the Ohio State Bar Association, Stephanie is licensed in Illinois and Ohio and is admitted to practice in the U.S. District for the Northern District of Illinois. She has been listed in the Ohio Super Lawyers Rising Stars list for the past 2 years. Without any further ado, I will go ahead and hand it over to our presenters, and we will get started.
Thanks, Hallie, for that kind introduction, and thank you all for joining us today, and good afternoon. Today, next slide, Hallie, we're going to talk, give a brief overview of the FCRA and UDAAP, and then we're going to talk about how the Cares Act and COVID-19 affects both of those acts. We're also going to go through the repossession process, and we're going to talk about what COVID-19 is doing to repossessions right now, especially with sales. Commercial reasonableness is a big topic, and that's we hope you all enjoy. And please feel free to ask questions during the presentation. If we have time at the end, we're going to answer questions. If not, reach out to us. Both of our email addresses and phone numbers are at the end of this presentation, so please feel free to ask questions.
This is Amy. Thank you for coming today. I know we're all busy in the new world in which we live, so thank you for taking time to be here today. Most of you, I think, know our firm. I saw on the attendee list a number of clients, so you know what we do, but we are a full-service creditors' rights firm. We practice in the area of real estate default, bankruptcy, litigation in both consumer and commercial, and do a lot of collections work. We view your reputation as our clients as one of the most important things we protect, especially in the climate in which we live today. So you know how to reach us at weltman.com. Next slide, Hallie. So we're going to talk a little bit at the beginning about the FCRA, or the Fair Credit Reporting Act. This act was established in 1970, but there have been multiple amendments to it since its enactment. It went active in 1971. It's sort of important to know that credit reporting has been going on since at least 1899. There was a company called Retail Credit Company, which is now what we all know as Equifax. And prior to the act, there were some significant concerns about what was being reported on these credit reports, because it went further than someone's ability to pay a debt or how much income they had coming in. It was covering things like marital status and things like sexual orientation. So there was a great press around that time to put some regulation in place. The FCRA was also the first act that started to talk about consumer privacy, the right to have some information that shouldn't be disclosed to third parties. So it is the oldest act that we have on a federal basis that protects consumers' rights. If you take nothing else from what the FCRA does, you should know its purpose, which is to promote accuracy, fairness, and privacy. And as we go through what's going on in the current climate, Accuracy is going to be the key for understanding what you should be doing as a lender or a finance company. It offers benefits to the consumer in that it is supposed to give a complete picture. It is also supposed to be accurate and private. It offers benefits to business in that it helps evaluate creditworthiness, which that accuracy you need as a lender when you're going to extend a loan to another party. It also is used in employment and insurance. So lots of people, it's easy to get narrowly focused on what a credit report is and who's using it and what data is going in. It's a lot broader than what you initially think. Hallie, you can do the next slide. So there's two bodies that are covered under the FCRA, two people who are required to act. First are the furnishers. Those are going to be the banks, the credit unions, credit card companies, finance companies, but it extends to anyone who's reporting. So that could be landlords, that could be, I've seen private schools reporting. So anyone who's providing data is considered a furnisher. Then there are reporters. And those are the big three we always think of, right? There's Experian, Equifax, and TransUnion, the big three that everyone reports to. But there is a world of small reporters who are reporting on regional or on specialty basis. One of the things the FCRA allowed through an amendment was for there to be a web. So when you report something on TransUnion, it's possible that it gets picked up by one of these regional credit reporting bodies. So that when bad information goes in, it can spread like a virus. I hate to use the word virus in our climate that we're in today, but it can spread. And that is one of the, well, we're allowed to share data. The accuracy of that data has to be first and foremost. Information needs to be reported completely and accurately and in a timely fashion. And one of the things you really have to keep in mind is that furnishers, lenders, might also have to investigate disputes that arise from consumers. Next slide. So the standard is that you should not be furnishing information that you know is incorrect. Now, if you have reasonable cause to believe is incorrect, that's a very defined term. It means specific knowledge other than allegations made by the consumer that would cause a reasonable person to have substantial doubts about the accuracy of the information. Now, that's a mouthful, but the thing to take from that is a mere consumer complaint is not enough to have furnished bad information. There has to be something else that's been an alert that you have knowingly provided bad data. So let's talk about the next slide, which is about the dispute. The FCRA creates a very organized way for a consumer to dispute incorrect data or things they think are inaccurate on their report. And there's a section of the FCRA that creates an exemption or a preemption, meaning that if I'm a consumer and I think there's something wrong with my data that's being reported by a credit reporting agency, then I have to take specific steps in order to have that corrected. The notion behind that provision in the law is to cut down on simple errors that can easily be corrected. We don't want everyone who has one piece of bad data, maybe a student loan that's listed at the wrong amount, to have grounds for a lawsuit. Maybe it's a simple error and can be corrected. Now, normally what happens in these disputes is that the consumer goes to the credit reporting agency. So I pull my TransUnion report and I notice that there's an error on it. I then send my dispute to TransUnion. TransUnion then determines if it's an error on their side, and then they're sending that dispute over to the lender to take a look at if they can't narrow it down themselves. There is one kind of exception. In 2003, the Fair and Accurate Credit Transaction Act was passed. It's a subpart of the FCRA. And that provides that if it is fraud, that is when we get a consumer who comes in and says, my stepdaughter took out this account in my name, they can go directly to the lender. So a lot of you I know, because I work on cases with you, call me up with, we have an allegation of fraud. That's why you have your internal fraud investigations. That's why they don't have to go directly to the credit reporting agency, but can come to you directly. Now, the one thing under FACTA is that, and that's that second act I just told you about, the request or the dispute can't come from anyone but the consumer. It's actually provided within the statute that you can't have a debt repair company come to you. It has to actually be the consumer who comes to you and raises the dispute for fraud. Next slide. So now you're on the receiving end. You're the lender, and you've received notification from a reporting agency that there's a dispute. What do you have to do? The three things you have to do are investigate, report, and update if needed. So we'll talk more about what the investigation entails, but those are the big three items that you need to contemplate whenever you see one of these come in. Next slide. So what goes into an investigation? You've got hit with one of these, and now you need to know what to do next. The first thing you want to do is start pulling your loan file. Take a look at the application, look for signatures, who's actually liable, who owes this money, were the procedures followed that should have been followed at the application's inception? Was your protocol and your procedure followed? Are there proper backup data? Do you have copies of driver's license? Do you have pay stubs? Do you have proper signatures? The next thing you want to sort of look toward is payment application. Are payments being applied correctly? Is the balance correct? And is there really a default? Now there's a really specific timeline on this. From the time that you receive the dispute, your clock starts to tick. You've got to run your investigation within 30 days. I would also advise that when you're doing these investigations, you're keeping a record of the investigation. What did you review? When did you review it? And who looked at it? This documents, if this doesn't go well, so that you have something to go back on. You know what your internal procedures are. Also, make sure you have a written procedure in place for how you're going to handle these credit disputes. Next slide. So what do you do?
Question.
Oh, okay.
The question is, how can you determine if the dispute is coming from the consumer or a debt repair agency? Some look like form letters, others do not.
When in doubt, assume it's the consumer. If you are uncertain, you have to err on the side of caution on this, because ignoring the dispute because it came from maybe something you can't really differentiate, you're going to violate the statute. So it's going to be a reasonable person standard again, but if it looks like it comes from the consumer, when in doubt, go with the consumer.
Thank you.
So you're going to get some disputes, right? And you've probably all seen them, where you get a letter in the mail. I don't think I owe you any money, or I think my interest rate is unfair. The dispute actually has to contain information that lets you have the knowledge or have the information so that you can investigate it. So there are going to be disputes that are deemed frivolous. Has it come in more than once? Is this the same dispute over and over and over again? And you've already investigated it and you've already looked at it and nothing has changed. Now, if you've had something change in the reporting, you probably want to run a second investigation. But is it simply just frivolous? If it is, you get a 5-day window in normal circumstances to make a determination and report back that the request is frivolous. The reason that it's sort of set that way is so that when the consumer gets it back, if it is a consumer who might have a legitimate issue, they can rephrase their dispute and do it correctly. Also, I would always check to see if it's the liable party. I'm always shocked as a lawyer the number of times, and Stephanie probably is too, by interested parties who aren't actually the debtors who want information. Again, you are disclosing personal and private information, so make sure when you're doing that, you know that it is your consumer, your debtor, your borrower, who's liable on this account. Next slide. So the Cares Act has done some things that have changed the FCRA effective on March. And what has happened is it's applied to the furnishers again, those mortgage servicers, credit card companies like we talked before. And we are in a time when a lot of financial service companies have been encouraged to do some forbearance on delinquent accounts or modify loans, or just make general assistance to the borrowers. And we're going to call those accommodations as we go through this. The one thing to remember, though, and the one caveat is, if a debt is charged off by the time the Cares Act went into effect, nothing we talk about is going to apply. You're going to do that exactly the same as you have before. Next slide.
Looks like we have another question.
Okay.
This question is, what determines a frivolous dispute?
So it's going to be one that gives you so little data you can't actually investigate it. So let's say you've got a member at a credit union who's got 4 accounts, got a signature loan, a second mortgage on his home, and a car loan. And you send you a report that says, I don't think I owe you the money I owe. And I've seen these reports. How would you possibly know which account to investigate? And asking you to investigate all 3 is onerous. So instead, you would send back the frivolous notice that this is frivolous, it does not contain enough data for us to investigate. That gives him the opportunity then to come back and give you more data. Now, we've all run into the borrower or the member who is difficult. Be cautious, because just because they're a difficult person does not make their request frivolous. So you're going to have to weigh it, take out any of your personal knowledge of that person and their reputation, and if an investigation needs to be done, to do it. But you're going to know, because you won't have enough to do a proper investigation. So one of the big concerns about this CARES Act is that it does create greater exposure for furnishers. The FCRA has always allowed a private cause of action, which means that if I follow the steps and I make my dispute appropriately, I can then sue the lender, for actual damages, attorney fees, and court costs. Actual damages might be, I had to pay a higher rate of interest because you reported my credit incorrectly. Attorney's fees, you all know, those can get costly and out of control. Under this, so that is your exposure. Now, the other one I want you to keep in mind is there's also 2 levels of FCRA violations. There's a regular violation in which you have done something that is incorrect. But there's also what's called a willful violation. A willful violation has a higher standard that the consumer has to reach, but it entitles them to actual damages or statutory damages. Statutory damages can run $100 to $1,000 for each violation. So if you've done multiple violations, that gets costly quickly. The next one you can be exposed to is punitive damages. Punitive damages are what I think of as punishment damages. The court awards those because you've acted poorly, and they're punishing you for the behavior you've done. And again, there's attorney's fees and costs. Also, the other thing to be aware of when you're doing your credit reporting through this is that there's no statutory maximum for damages in class actions. And there have been class action litigation for FCRA violations. So with these changes under the CARES Act, with this greater scrutiny of what's going on, there's going to be more exposure. Also, the CFPB can pursue a furnisher. Knowing violations brought by the CFPB can have a price tag of $2,500 per violation. So violation costs and expenditures can be very costly to a furnisher. And really, what I want you to take from this, ultimately, is that when we're making these accommodations, which are kind and good things to do for our members and our borrowers, to make sure those accommodations are being reflected in the credit reporting. It goes back to the whole concept of accuracy. So we're going to talk about that. Next slide.
We have 3 questions.
Okay.
Okay. The first one is, what if you receive a written and electronic dispute for the same reason? Do you have to respond to both?
So you've got an email, is that what I'm to assume? Or you've got, and it's duplicative coming from the same person. I would count that as one dispute. I might put the report back to both sources if that's your policy internally. But if it's coming from the same person around the same time, containing the same data, so it's not a separate complaint, then I think you can count that as one dispute as long as you respond accordingly.
Thank you. And the next question is, what is a reasonable standard of investigation for an allegation of fraud or identity theft in an account opened online? Are there other things lenders should verify beyond name, address, social, and amount owed?
You might look at the payment history. How are the payments come in? Who have they come from? In the electronic world in which we live, that's not always so easy. Also, make sure the account was opened. Online accounts are fine, and courts have upheld that data concerning your online application is enough to meet your investigation. but make sure that the policies and procedures internally were followed. Watch for, I would also pull your history notes to see if there were any calls made in, particularly on an electronic account. Did anyone dispute this before? And generally, I think what you've provided is adequate, unless there's some other flag on the account. I have seen investigations that have gone poorly in litigation where a minimum of data has been pulled, and it turned out that when it went to litigation, there was evidence that the consumer had called in multiple times indicating this was fraud. And from the onset of, like, when late letters were being sent out. And the courts are not going to look favorably upon the fact that a consumer can provide evidence that they called in, that there was, not doing the formal request yet, but where their calls in were notated or weren't notated. It doesn't look good. So, what's my next question, Hallie?
The next question is, what if they keep sending you requests that do not contain any new information and you have already researched and responded, and they just keep saying we are missing reporting without stating what they are disputing is incorrect?
Again, those are frivolous requests. So, most of you are going to have, I'm going to guess, template letters out there that we received your dispute, we reviewed it, and it's frivolous. You're going to tell them that it's frivolous.
Okay, and one more question just came in. Reporting a loan in COVID-19 forbearance, i.e. suspended payments, current is manual. The loan is not delinquent. This is not reasonable. Any proposed changes in this requirement?
All right, repeat that for me, Hallie, please.
Reporting a loan in COVID-19 forbearance, i.e. suspended payments, current is manual. The loan is delinquent. This is not reasonable. Any proposed changes in this requirement?
I'm not sure. I wish I knew who my question person was, because I want to ask them a question. Stephanie, did you hear it too? Did you?
Yeah, I did. It sounds like, so the question is that the loan has now been in forbearance. It's not current. But if it was an accommodation plan that was reached during the pandemic, then you're still going to have to report it as current. That's what I kind of took the question to.
Like, the one exception I would think of is that if the loan is 120 days late, the accommodation is for 60 days. You can still report that loan delinquent for the 60 days. You don't have to, if the accommodation doesn't bring them current, but you gave it to them anyway, you would have to report it as delinquent, but not for 120, but for 60. So again, it's about the accuracy. Any more questions, Hallie?
Not right now.
Let's go to the next slide. The accommodations that we're seeing, deferring one or more payments, I think the highest number, and I did some research about what lenders are publishing at least, is that about 90 days is what I'm seeing in deferred payments. Partial payments, forbearance agreements, loan mods, or any other borrower assistance. So if you're going to extend an accommodation, you can't, and Stephanie just sort of covered this, if you're going to set forth an accommodation where you're going to waive payments for a period of time, you can't mark that loan as delinquent when those payments that have been forbeared aren't being made. It's the whole concept. And I want you to always remember that the FCRA's underlying purpose is accuracy. So if you have agreed that payments are going to be waived, you can't go ahead and mark that loan as delinquent. I would also advise you to be very careful of the accommodations you're making. Make sure that the parameters and terms are set out so that it's clear to both the lender and the borrower what that accommodation is going to be. Now, also keep in mind that if a borrower violates an accommodation, let's say it's partial payments, and those partial payments aren't being made correctly, then you do need to report it as delinquent. So the accommodation is almost like a loan modification in that you are changing the terms of the loan, but the borrower still must adhere to the terms of that agreement. So that's why it's important that the terms of your accommodation be really clear as to what you're offering. Also make sure when you're doing this too, that what someone has to do to ask for an accommodation is clearly set forth. I have some clients right now who all someone has to say is, it's COVID-19 and they're entitled to a 90-day stay in payments. That's their policy. Just make sure that's being applied equally across the board then to everyone who calls in. If you're requiring some kind of evidence of a reduction of hours or termination of employment, make sure you're putting those, you're doing it the same for all your members or all your customers. Next slide.
We have 2 more questions.
Okay.
What if you need more than 5 days to research a dispute?
It's 30 days for a valid dispute and 5 days for a frivolous dispute. And we're going to talk about that and what it means under the Cares Act too, because that actually 5-day window is actually waived. But it's 30 days to do your investigation.
Thank you. And the second question is, if the borrower is in a COVID forbearance for suspended or partial payments, the borrower is current, do you still report forbearance as a special code?
You could, and also you could put it into a status. There's the CFPB's created a national disaster status. It's called AW, which no one's really using, but you could also put it in the AW, which is the national disaster. It was in 2017 a recommendation by the CFPB as it related to Hurricane Harvey. So that's the other thing you can do.
Thank you.
So again, if you had someone who was delinquent before the accommodation and they remain delinquent, you still report them as delinquent. Accuracy, again, make sure that you're following the guidelines for that. Also, if in the meantime the accommodation brings the person current, you're going to have to reflect that because that accommodation made them current. Remember too, this does not apply to your charged off account. So you can go to your normal procedures for charged off. Next slide. So we always look to the CFPB, whether we want to or not, for guidance on what they're going to do and what they're saying. The CFPB has indicated, and again, we always hope that, indications isn't always law, but as long as people are putting good faith efforts to comply during this period of time, then that will be looked upon favorably. Also, dispute time has jumped up to 45 days, so you've got a little more time when these disputes come in to take a look at them. And the requirement for frivolous response is actually waived during this period of time. So when you get the frivolous ones that are just like, I don't owe you any money, you can disregard those without having to send any kind of notification. The other thing that CFPB has told us is that if a furnisher has reasonably relied on an interpretation of law that's erroneous but not objectively unreasonable, they're not going to pursue those cases. That standard is going to be lowered. So as long as we are trying to do this correctly and in such a short amount of time, it appears that the CFPB is not going to pursue these. The takeaways are this. Be careful for negligent noncompliance. Make sure that you have a plan in place for how you're going to report this information during this period of time. Make a good faith attempt to modify how you're furnishing the information. And be careful about unintended accommodations. Be clear and precise with your borrowers and your members so that they know what these accommodations are, what they're valid for, and how long they last. We will see litigation after this because whenever the law changes quickly, we always have that, we always have people pressing the button, pressing the issue. So I would say litigation will see some of it, but if you're doing your best and you're following the guidance that we have, you should be okay to survive through this really kind of crazy, turbulent time. Next slide. And then this is that AW code I was talking to you about. It was created in 2017. You can code it for that. And that would be one of those things where you have an affirmative member or borrower coming in saying that this accommodation is for COVID-19. You wouldn't apply it to every one of your members or borrowers. But you could use that as for your reporting purposes. Next slide. Steph, I think.
All right, thank you. I had to put my phone off of mute. I've got a toddler in the background making some noise. So thanks, Amy. Stephanie, we're going to talk now, switch gears to UDAAP, to unfair, deceptive, or abusive acts and practices. This is a much newer body of law than the FCRA. It really came about in 2010 after the Great Recession of 2008 as a response to all the banking violations. So this was created by the Dodd-Frank Wall Street Act. Again, it gives the CFPB enforcement authority, and it applies to all consumer financial products or services. So anyone who's providing those services, you have to engage in fair, non-deceptive, and non-abusive. The UDAAP is so subjective. It's, as you're going to see, it's constantly evolving. The CFPB actually just announced back in February of this year a new determination of what is abusive. So it's something that's constantly evolving, and I think we're going to see more litigation after the pandemic ends, and maybe even some more definitions from the CFPB. All right, next slide, Hallie. All right, so we're just going to take apart each section of this act. So what is unfair? So something's unfair if it causes substantial injury to your consumer. It's not avoidable by consumers, and it's not outweighed by countervailing benefits to consumers. So an example of this would be a lender that's unreasonably delaying releasing a lien when your consumer has already paid off their mortgage loan. So we also want to make sure that the consumer has obtained credit with the most favorable terms. So by not releasing the lien, perhaps then on the credit report, it's still showing that, and that's unfair. So next slide, Hallie. All right, deceptive. So deceptive is probably the most sued by the CFPB. The CFPB can choose what to sue a lender, a financial institution. It can choose to sue with both unfair, deceptive, or abusive, but it seems like deceptive is what they choose to go after. So what does it mean to be deceptive? It's going to mislead or likely to mislead your consumer. Perhaps your consumer's interpretation of it is reasonable under the circumstances. And I think this is the most pertinent to today's climate. So right now, everyone is rushing to get out these accommodations, which is great. And the CFPB has also encouraged and said it's great that everyone's trying to give your consumer these accommodations. But the problem is that you've got these desperate consumers, and they're wanting whatever you can give them, a payment plan reduction, a deferment, a loan modification, but they might not understand what that actually means. So the problem here is that your consumer may not have a clear understanding of what the new terms and conditions are of this accommodation. So things to remember: does your interest accrue? What does a deferment actually mean when they have to start making their payments in 6 months? Are you going to have a lump sum payment of those 6 months of payments, or are they going to start back on their original payment plan? So you want to be really clear with your consumer of what it means. What does this accommodation actually do for them, and so that they have a clear understanding. Another thing to keep in mind with deceptive under the CFPB is that actual deception isn't required. So it could just be your mere silence, that maybe the consumer has some questions and you're just not answering them. It could also be actions that you say you're going to have this payment due in 6 months, but you don't clarify what kind of payment is due. Those are types of things that are going to get you become liable under UDAAP. Also, another thing to point out with deceptive is that acting in good faith is not a defense for deceptiveness. So again, all this good faith with your accommodations, but you really have to be careful that your consumers are understanding what these new accommodations do for them. All right, next slide, Hallie. All right, abusive. So this is a new definition that was just created back in February of 2020. Like I said before, the CFPB is constantly evolving with these definitions through its enforcement actions. So abusive, as you can see, this is going to materially interfere with the ability of the consumer to understand a term or condition of the consumer product. So again, this is really pertinent with today's climate because your consumer might be so desperate to get these accommodations that, again, they're understanding, they might not understand what this actually does. The interest that's going to accrue, that they might owe more money at the end of their loan, or that they're going to have a big balloon payment at the end of it. So again, you have to be really careful about what the costs and what the terms of these accommodations are. All right, next slide, Hallie. All right, so we're going to talk about, again, kind of going back on my point, that these accommodations are fantastic, but be really careful when you're explaining these to a consumer. Put it in writing. Make sure that you've got your ducks in a row, that you've covered everything with your consumers. You know, what does this mean? And again, going back on what Amy said, make sure that you're applying this to everybody, that you're giving these accommodations when you're looking at your portfolio to everyone. That way you're not unfairly giving accommodations to certain folks. All right, next slide, Hallie. All right, so UDAAP was really created out of the Great Recession of 2008. What I've kind of been reading about and looking at is sort of this heightened vigilance that might come out of this. So the CFPB right now is getting a historic number of complaints. And it's actually interesting because the complaints that they're getting aren't about debt collection, which is normally what they've received. But they've actually gotten, I think, twice the number of complaints in April and May, and it's from folks complaining about their mortgages and about mortgage accommodations. And it's actually from an older group of 62 and older. So that kind of tells me that we're going to see some increased litigation with UDAAP, that the CFPB, again, is saying that these accommodations are great and that they're going to be, kind to some of the financial institutions, but I think the number of complaints that they're getting is most likely just going to make them look for more violations. All right, next slide, Hallie. All right, we're going to switch gears and we're going to talk about repossession. Just do a quick overview. So before you're even thinking about repossession, you first confirm your consumer is in default. That seems silly, but we see a lot of interesting things in our line of work, Amy and I, so make sure your consumer is actually in default, which is per the terms of your agreement. Next thing is your collateral even worth the cost of repossession or replevin? Are we talking about a 1995 Toyota Camry or something that's more recent that actually has value? Replevins and repossession isn't cheap, so make sure it's actually worth it to your financial institution. Confirm your lien is properly perfected. Do you have your title work? Make sure you're actually on the title. Those are just things to think about and to check kind of off your list before even thinking about repossessing a vehicle. The FCRA, make sure your consumer isn't in active military service, so run a SCRA search, and also make sure your debtor or your consumer is not in active bankruptcy. All right, next slide, Hallie. All right, self-help repossession. So this, make sure you're, with your repossession agents, you're auditing them. Make sure they're not breaching the peace. So something to think about here is in some states, actually, trespass could be on a consumer's driveway. There are certain states that don't allow repossession agents to come on someone's driveway, which in Ohio is completely allowed. But you need to make sure that your agents are following the law and not breaching the peace, because that could come back in litigation or a counterclaim down the line. Another thing to think about on this is with Native American reservations. They have their own set of laws, and they actually don't allow self-help repossession. At least I've not seen one yet allow it. So make sure your repo agents aren't going out to a reservation to engage in self-help repossession, that you're actually filing your replevin action within that Native American court. All right, next slide, Hallie. All right, personal property. So this is stuff that's in your car. So when I think of my car right now, I've got the car seats and a bunch of toys and sippy cups and other stuff that I would want back if somebody took my car. So make sure your repo agents are properly inventorying this, the personal stuff that's in there. So this isn't the car stereo. This is the stuff that's in the car. So the CFPB issued an advisory opinion back in 2016, and we haven't seen anything more recent than this 2016 opinion. But in the opinion, the CFPB opined that it's unfair for financial institutions to charge consumers storage fees. So the CFPB requested that financial institutions completely waive the storage fees and allow consumers to come back and reclaim their property. Again, this is just an advisory opinion. It's not actually been codified in any law, and I haven't seen anything further on it from the CFPB. Doesn't mean they won't change and make something in the next few years, but that's current as of today. State laws. So different states have their own set of views on what to do with personal property that you find in cars. So some of them will actually have you listed out in the notice of sale that, here's where your personal property is located and here's how you can get it back. And oh, by the way, you might owe some storage fees. And here's, how much you might owe. So look at those, make sure before you're sending these vehicles out for repossession or sending your letters out, if there's any nuances with these states. Another area is in contract language. We've seen a couple states actually in the West that, depending on what your language is in your retail installment contract, or if you have a direct loan, your just automobile loan, that it might have a blurb about personal property in it. And so there is some case law that has come out that if personal property can be picked up by the consumer and maybe it even has language in your contract about how many days they have, that could be still relevant and valid. And you might have to give notice to your consumer to come pick up their personal property. So just things to be wary of and to maybe take a little glance back at your contracts and also to think about with personal property. All right, next slide, Hallie. All right, repossession letters. So you have to send repossession letters. You can't not. These are governed by state statute. Every state has its own little nuances. The guiding principle over everybody is Uniform Commercial Code, and all states have enacted the Uniform Commercial Code. Some have changed it slightly. If you're in Louisiana, they've changed it a lot. But every state has either abides by the Uniform Commercial Code, and then on top of it has some sort of consumer statute. So whether it be a Retail Installment Sales Act or some other protection statute that changes either the timelines or requirements slightly. So be really careful on what state you're in because that's going to change what your letters need to be. All right, next slide. Okay, so before you even send out those letters, you got to decide which state's law applies. So things to think about: where does your consumer live? Where is the contract signed? And where is the collateral located? Hopefully, and then I would say in most instances, these are all going to be the same. So everyone's in Illinois, contract's in Illinois, your car's in Illinois, great. But then you've got the weird cases where your consumer is down in Florida and your collateral is in Texas. Well, what do you do then? So we're going to have to, we always advise to call us, call your attorney. We're going to do an analysis to figure out where's the best place to send these letters and which state's law is going to apply for this. We're going to look at which state might have greater interest in this case and which state is going to have a greater consumer protection law, because we're typically going to choose that one. We're going to always err on the side of caution to give the consumer the most amount of protection we can, because that's going to really save you in the end. All right, next slide, Hallie. Okay, so this is a letter that is really the least required letter. A couple states, like Minnesota is one, you're going to see this notice of strict compliance. So if you've accepted late or partial payments in the past, so let's say your debtor sends in a late payment every month and you continuously accept it, and then suddenly now in June you're like, no, I'm not going to accept it anymore. I'm going to set this for repossession and we're just going to take this car back. Well, you might have actually waived your payment date, and that's where this letter comes in. So this notice is going to set forth, and it's going to be sent to your consumer and any co-signers that you know that you've accepted these later partial payments in the past, but you're no longer going to do it. The debtor's payment is due June 15th. You expect payment by that date. You expect the actual payment on that date. And then if it's not received, then you're going to place this car for repossession. So this letter is, again, it's only really required by a few states, but I think overall it's a really great letter to incorporate into your portfolio, just in case the law ever changes. Really, it covers any ambiguity that you've let your debtor know that, you know, hey, you can't send in these later partial payments anymore. We're actually going to follow the contract. All right, next slide, Hallie. All right, your right to cure letter. And again, this letter is really only required by, I would say, a handful of states. But this is going to be your letter that goes out to your consumer and any co-signers either before or after repo, depending on which state you're in. So again, a big thing to look at is your timeliness requirement. How many days do you have to give the debtor to cure? Is it 10 days? Is it 20 days? Every state has something a little different. The method of mailing. Most states will have you actually send this out by certified mail. There are a few states that say that, you know, regular mail is their preferred method. So things like that are really important to make sure you've looked at before sending this letter. And also look at your contract. What type of loan do you have? Is it a direct loan or is it indirect lending? What's your paper? That's going to be really determinative in a few states that actually make the difference between a direct or indirect loan. All right, next slide, Hallie. Okay, your notice of sale letter. So now you've taken back that car and you're going to have to send this notice of sale letter. So what this letter does is it's going to lay out how the vehicle is going to be sold. So is it a private or public sale? You have to pick one. You can't pick both. We've seen some lenders pick both. It's an either or. So you're going to also, if it's public, you're going to have to list out the date, the day, the time, and the place of how this consumer can come and bid on their car. Because they have the right, if a public sale under the UCC, to come and bid on their car and to bring any other bidders if they so choose. If it's a private sale, then it's a dealer-only sale. The consumer no longer has that right to come and bid on their vehicle. But you still have to list out the date and the day of the private sale. So time requirements, again, this is going to depend on each state. The default under the UCC is 10 days for a commercial matter. For a consumer matter, we really recommend at least 2 weeks. So a 14-day time period between the time that you're sending out this letter and the time that you've marked that this vehicle is going to be sold. But each state might have something a little different, so it's really important to check before sending out to make sure you've got enough time in between. Methods of mailing, again, same with the right to cure letter. It's going to depend on your state. But what this letter also lays out is your debtor's right to redeem. They're always going to have the right to redeem, which means they're going to have the right to pay in full. But sometimes they're going to have the right to reinstate. So they might have a weird state, like Illinois is going to have some nuances. So make sure you, again, have checked and you know which state you're in. Amy's going to get into this more at the end of the presentation, but the simulcast consideration, we're seeing more and more auction houses that are just going online, that they don't want any bidders to come. So what does that mean? Well, we believe that you're going to have to give a heads up to your consumer, and the best place to give them a heads up is in your notice of sale letter that this sale is happening on such and such date at such and such time, and this is the place. Oh, but also it's going to be held online. So again, you're going to give all the relevant information, but you're going to need to also give some extra information just because of COVID-19 and kind of what this pandemic has done to our auction houses. All right, next slide, Hallie. All right, so your vehicle is sold, and now you've got your post-sale letter, which is typically going to be your letter of deficiency. I think I've only seen a surplus once. So this letter is going to provide how much the debtor owes if it's a deficiency. But be careful, there's a specific accounting method that the UCC has, and there's only a few states that kind of change that with their consumer protection laws. But there's a specific way that you have to apply the proceeds of the sale to the balance due. So make sure you're actually following that. Amy and I have seen multiple matters where it's not followed, you've not followed that accounting method, and that's what's going to get you in trouble. There's also some specific language that you're going to have in the post-sale letter that, again, has to be in there. It's provided for in the UCC, and that's just going to be standard across the board.
As a general rule, too, this post-sale letter if this is the letter that is messed up, it is usually the least damaging. But there are occasions in certain states where it is more damaging than not, and sometimes they're out west, and sometimes they include personal property information after the fact. So just be aware that it's an important letter. Generally, I don't know, Steph, if you agree with me, but I think of the 4 letters, this is the one that has some hyper-technical things. But in Ohio, for instance, I believe the statutory damage is $100. So
yeah,
and it doesn't have an independent cause of action. People raise it as a counterclaim or as a defense inside of a collection suit. So it is usually the least frightening of violations, as far as not all violations are slightly frightening, but this one is the least usually.
Yes, thanks, Amy. And just so you know, so the timing on this letter, so you have to send this letter before you make any demand on the consumer. So you can't send a demand letter for the balance due without sending this letter first. So make sure you get this letter out. There's only a handful of states that actually do have a timing requirement on when you have to send this letter out. So make sure, again, you know which state you're in, because some states do have a timing method. It's really is just to piggyback off what Amy said, the notice of sale is what's going to get you into trouble, I would say a majority of the time, that and your right to cure letter. So those are the two most damaging that you really have to make sure that, one, you know which state you're in, but two, you're following the law to a T. Next slide, Hallie. All right, so just some common errors. So the first one, you say you're going to sell it by private sale, but you end up selling it by public sale. Again, really make sure you know what kind of sale you're holding and you give your consumer all the information. You want to make sure that you're following any time constraints. You're also sending this to any other guarantors, your co-signers. Make sure you're including them and sending those notices too. There's a few states that actually have specific notices for co-signers. So again, make sure you know which state you're in. There's also some other, again, the nuanced errors where you don't have the location. So there's some states that actually require you to put where the car is located right now. So make sure you have that. Incorrect itemization, that goes back to your notice of sale letters. Make sure you're following that accounting. You have to follow it. Otherwise, that's a really easy error and a really quick error for consumer and consumer rights attorneys to find. All right, next slide, Hallie. All right, and then just some damages. The most common that we see is your waiver of your deficiency balance if someone files a counterclaim. that you might just end up walking away from your suit with nothing, but with a mutual dismissal. There are some statutory damages, and then there's some actual damages too. Some of these, which we've seen as these class actions that have arisen, especially in Ohio with these consumer rights attorneys, where the damages can actually get quite high, into the $1 million range for notice of sale violations. So make sure you know what you're sending, you've got the right state, and your information is correct within those letters. All right, next slide.
Okay, well now you're back with me, and so you've got, Stephanie just walked you through, you've taken back a car, you've notified them that you're going to sell it. I'm going to talk a little bit about that sale and what's the expectation, because in this time and place with the pandemic ongoing, we've got to weigh a couple things. But what we know, right, is that we have to sell this vehicle in what's called a commercially reasonable way, and that applies to the time, place, method, and manner of sale. Can't sell a car at 1 a.m. in Cleveland from your uncle's driveway. I mean, I think you've got to make sure that how these vehicles are being sold is done commercially reasonably. And it applies to both public and private sales equally. So when we're looking at commercial reasonableness, we go back to the UCC. What's the intent? When they use that phrase, what's the intent? Well, what we know is this. Sales were designed and the rules are set up to protect debtors from creditor dishonesty. And we're supposed to minimize the interference with honest dispositions of collateral. So we want to make sure the wrongdoers aren't doing wrong, and we want to maximize value. There's good reason for that, right? Because we want the maximum value. It serves both the consumer and the lender. So in this kind of time that we're in, we're weighing a couple things. We see a lot of these simulcast sales, and what we have to make sure is there's enough bidders that we're getting reasonable prices. But we also can't hang on to collateral for such a significant amount of time that it's depreciating too quickly. That's bad for the creditor, bad for the consumer. Next slide. So what goes into determining commercial reasonableness? Next slide, Hallie. Price is not just it, okay? But in every litigation suit, it's always going to be the first thing they raise. You didn't get a good enough price. But we know that it's a weighted factor, but it's not the only factor. Was it sold in a fair and honest way? How was it advertised? We want to make sure that these sales, and that we're keeping records of how these sales are advertised. I'm seeing a lot of Facebook. I'm seeing a lot of still newspaper. Newspaper used to be your kind of safe harbor. If you published in the local plain dealer, then you were good to go. I would argue probably now that might not be enough. You're going to need some advertisement online. You might need Facebook. Newspaper readership is at an all-time low, so we want to make sure that those are being sold appropriately. We also want to watch how many bids are being received. I've seen lots of canceled sales, and that's appropriate when we can't get enough bidders, especially for these simulcasts. If we're not getting enough people to show up, we've got to make sure that it's reset. When it's reset, however, you're going to need to re-letter it, especially for public sales. So I can't tell you clearly enough that reset sales are oftentimes what people mess up on the letters too. When you have to reset a public sale, you have to send new notice. Remember, the debtor is entitled under almost all these statutes to show up with other people and purchase their collateral back. Also, you've got to take into account whether or not the collateral needs to be improved. And that's going to be a weighted decision. How much work do we put into a vehicle to get it ready for sale? And is it worth it? Is it an investment worth putting into a vehicle to get it out there and back on the market? Kelly, next slide. So there's a safe harbor provision that UCC gives us, and safe harbors are kind of what we try to follow. What we're looking at is what everyone else who's similarly situated is doing. And in these simulcasts, it appears that we're pretty clearly, this is the new normal. And in this time and place, this is how sales are getting done. But we've got to watch your floor pricing and make sure you're setting your vehicles at appropriate sale prices. Stay away from the unusual sales. Steph and I will tell you that we get calls from, hey, there's this online auction and I want to auction off my car, but it's like Bob's auction. No, stick with the guys who are auctioning off your collateral, but also watch for unusual collateral. Today I had a case across my desk. it's a fancy RV, one of the over $100,000 RVs. And an auction house wanted to sell it, but when I started talking to them, it turned out they'd never sold this kind of RV. And they only sell smaller RVs about 4 times a year. I would make an argument that unless they're going to do special marketing, special attempts to get bidders, I don't think we could sell it there. We had to sell it at an auction house that sells that kind of equipment. So watch for RVs, boats. Customized motorcycles are another tricky one. Sometimes those have to be reset for sale a number of times because a specific bidder is going to bid on that bike. Watch for commercial grade equipment. There are special auctions out there for that kind of equipment. Watch for trailers and mobile homes. Those are things that can be recovered. And then just generally watch for non-traditional collateral. There is a market for everything. I think Steph and I took back. Steph and I used to work in the same office. Gymnastics equipment. So we had to find someone who could sell mats and balance beams and uneven bars. But there is a secondary market for almost everything. So when you're getting ready to sell something, don't think you can just throw it into the market any old place. If you've got unusual collateral, sometimes you have to take unusual steps. Next slide. So we're doing these simulcasts. You're buying and bidding in real time. They're being used by all of the traditional auction houses. They seem to be going well. I talked to someone yesterday. They're having a 70% buy rate, meaning the floor set by the lender. So I think we're optimistic that this isn't going to be a huge issue, but it is still something to kind of watch. And I would expect, we always expect litigation when things change. And these laws are so case law based, this commercial reasonableness. We don't get a lot of guidance except when things go to court, unfortunately, which is bad for you. But I think these look pretty clean and clear as far as I can see at this point. Next slide. And the final takeaway is this: there's lots of things to take into consideration during this time. For a while, auction sales were super way down. They appear to be climbing back out of the basement. All of you are going to have reputational concerns. No one wants to be in the paper for being a lender who's overly harsh or has violated some part of credit reporting or repossessed a car when a jurisdiction said you couldn't. We try here at the firm to be extremely cognizant of your reputation is everything about how you get new members, new borrowers, new customers. So, and then watch your timeframes. I've talked a lot about those letters. Make sure you're sticking to your timeframes about when things need to go out. If you've got to break apart, some of you are doing combined rights to cure with notice of sale. You might have to separate those 2 letters to meet your timeframes. Make sure you talk to your lawyer to make sure you've got those timeframes sort of set out for yourself. Next slide. I know I speak on behalf of Steph, but we wanted to thank you so much for coming today and taking time out of your busy schedules. We hope we provided you some really good information. And if you have any more questions, please let us know.
I know we're running a little over on time, so if you do have an obligation to run to, do not worry. We will send everyone an email of the presentation and the recording. Otherwise, if you do have a few moments to stick around, we're going to try and get through the rest of these questions. There's just a few. The first one is, if a consumer's loan has been coded AW, however, no accommodations have been made, what does the AW accomplish?
Not really anything except to notate that that person has told you that they're part of the national disaster. We've not been given any kind of governance at this point that simply claiming that you have been negatively impacted by the pandemic is going to entitle you to anything, although you've notated the file. So.
Thank you. And how long are you required to keep the personal property?
Steph,
that's actually going to be, that's going to be state specific. So some states actually have state laws where I think the most I've seen is 2 years. I think that's kind of outrageous. But usually it's anywhere between 30 to 90 days. Again, that's just going to be state law. And you're also going to have to talk to your repo agent to see how long they keep it. Because if there is a short time period, you may want to give your consumer a heads up, again, on how to come and get their stuff.
Thank you. And if a person lives in their vehicle, do you have to evict them, or could you repossess it when it is not occupied by just hooking it with inventory contents?
So that
We've had these before.
I've actually done this before, and so generally speaking, if it's a property like an RV or a mobile home, you are generally going to have to do the eviction. Most of the time, though, when you do if you're doing a replevant action to regain possession, a lot of people move out independently. I've had one judge in Southern Ohio who actually waived the requirement for eviction and just threw the guy out in the middle of the pandemic, which I did not ask for, but he did in fact do this. And it was a trailer that we've been chasing for months. So, but generally, the general rule of thumb is if it's residential in nature, you can get your order of possession, but you're generally going to have to file an eviction to get them out. We've had the property back to you. Now we've got to get your tenant out of the property.
Thank you. And the last question is, the market has fallen out for buses and limos. When we auction the assets, we are not getting what we used to. Will the sales then be not commercially reasonable?
I would say you were probably safe. It is driven by the market. So remember, you're not obliged to sell it for more than market. And if the market is holding it down and you've done everything to create a method, manner, time, and place that everyone else in the market is using, you should be safe. Now, does that mean you won't get a consumer who wants to sue you? I can't control the consumer, but I can tell you that you've followed the law with the best guidance we've been given.
Thank you, and thanks everyone for joining us today. Again, we will be sending attendees a copy of the slides and the recording tomorrow. Be sure to check your whitelist if you don't see it in your inbox by the end of the day. Additionally, we will be opening registration for our next webinar early next week, which will cover unemployment law. We hope you can join us for that one. Other than that, that is all we have for today. Thanks again.